Hi, my name is Shlomo Katz. I'm a counsel at the law firm of Brown Rundick LLP. I'm in the Washington, D.C. office and practicing government contracts and wage and hour law. And our topic today is Introduction to Government Contracting. Government contracting, in some ways, is a lot like any contracting that you're familiar with. Basic concepts of offer, acceptance, capacity to contract, meeting of the minds, consideration, and contract interpretation rules apply to government contracting just like contracting. A would-be contractor makes an offer to the government and the government accepts it. The contractor has to have the legal ability to enter into contracts. The parties have to understand what they've and agree what they've contracted to. There has to be a meeting of the minds. Some consideration has to change hands. Usually that's payment from the government to the contractor. Sometimes when there's a modification to a contract, it might be the contractor paying the government. So these basic contracting concepts will apply to government contracting just like to any other contract. But, and that's why government contracting is a specialty in itself, an entire field, is that government contracting is very highly regulated by numerous statutes, regulations, and executive orders. There's the Office of Federal Procurement Policy Act of 1974, which includes within it the Procurement Integrity Act. That law regulates proper and improper behavior during government contracting. It prevents contractors from improperly getting competitors' information, from improperly offering jobs to government officials, and it imposes corresponding obligations on government officials. There's a Contract Disputes Act of 1978, which regulates how contractors and the government resolve disputes between them. You can't just go into any court and sue the government. The government has sovereign immunity. So that's what the Contract Disputes Act of 1978 was meant to address. There's a Competition and Contracting Act of 1984, which tells the government how to maximize competition, to get the best deal for the government while giving a fair chance to all the contractors who are out there who might want to bid. The main purpose of that is for the benefit of the government rather than the contractors, but that law generates a lot of the bid protests that we'll talk about a little later. There's a Federal Acquisition Streamlining Act of 1994, which was intended to actually reduce some of the regulation and in some ways make government contracting a little more like commercial contracting. The Small Business Act is designed to promote and assist small businesses in developing their businesses, including by getting government contracts. The Buy American Act and the Trade Agreements Act regulate how and when and under what circumstances the government will buy foreign products versus U.S.-made products or products of countries with whom the United States has treaties. The Anti-Deficiency Act is a law that tells the government not to spend money it doesn't have. That's why when Congress doesn't pass a budget, government contractors end up out of work. And there are more laws. The Service Contract Act and Davis-Bacon Act are laws that regulate wages and fringe benefits paid to government contract workers under service contracts in the case of the Service Contract Act and construction contracts in the case of the Davis-Bacon Act. There are a whole bunch of executive orders, some of them going as far back as President Lyndon B. Johnson, Executive Order 11246, which imposes equal employment opportunity and affirmative action requirements on government contractors, and many executive orders issued by President Obama in connection with government contracting, the non-displacement of qualified workers under service contracts, the executive order establishing a minimum wage for contractors, and the executive order issued in September of 2015 establishing paid sick leave for federal contractors. At the time that that this lecture is being recorded, we're in the middle of the presidential election, and one of the things you hear from some of the candidates is how they are going to withdraw the executive orders issued by President Obama, and that's actually typical of executive orders relating to government contracting. Each time the White House changes parties from Republican to Democrat or Democrat to Republican, the new president withdraws executive orders relating to government contracting issued by the predecessor and puts in new executive orders. And it keeps going back and forth from Bush to Clinton to Bush to Obama to whoever is elected next if it's a Republican. And so that is actually nothing new. Another law relating to government contracting is the Bayh-Dole Act, which is also known as the Patent and Trademark Law Amendments Act. And as the name suggests, it regulates patents and trademarks under government contracts. So if a government contractor would invent something, the Bayh-Dole Act would give that contractor certain rights and obligations. And lastly, there's the Federal Acquisition Regulation. Not to say lastly that there aren't others, but lastly in this long list I'm giving you is the Federal Acquisition Regulation, which essentially is the code for all federal government contracting, and it's the place to go to find out what the government and the contractor's rights and obligations are. We will be discussing the Federal Acquisition Regulation at length in a little while. The government also has unilateral powers in contracting that commercial contractors typically don't have. One is the right to make changes. If you're building a house for me and the plans call for a garage, and I say, I don't want a garage, I want a swimming pool, then you have the right to stop work and negotiate with me the cost of not building the garage and the cost of building a swimming pool. If I were the government and I said, I don't want a garage, build a swimming pool, you'd have to not build a garage and instead build a swimming pool and negotiate the cost with me later. Because I have the right to make, as the government, I would have the right to make changes within the scope of the contract. I can't tell you, don't build a garage for my house, build the Golden Gate Bridge. That would probably be outside the scope of the contract. But to make reasonable changes within the scope of the contract is a right that the government has. And the contractor has to just do it. And if there's a fight about the cost, that will be resolved later. There are also special ways of handling disputes. As I mentioned, the government has sovereign immunity. You can't just go sue the government. So the Contract Disputes Act and the Disputes Clause outline a procedure to be followed in the events of disputes. The government has the right to terminate contracts for convenience. In general contracting, in commercial contracting, you're probably familiar with a breach or a default, and the government has a right to terminate in the case of default. But also if the government just decides, I don't want this jet fighter or this bridge or computer system or whatever it is, I just don't want it anymore, the government has a right to terminate for convenience. And the contractor has certain rights when that happens, but there's nothing you can do to make the government buy something it doesn't want to buy. And in many contracts, the government has the right to audit and investigate the costs and other compliance with other terms of the contract. So let's talk about the Federal Acquisition Regulation. The Federal Acquisition Regulation is also known as Title 48 of the Code of Federal Regulations. It became effective on April 1st, 1984, and it's intended to contain uniform policies and procedures for acquisition by all executive agencies. There's something called the Federal Acquisition Regulation System, which consists of the FAR, the Federal Acquisition Regulation, and agency acquisition regulations that implement or supplement the FAR. So there's the DFARS, the Defense Federal Acquisition Regulation Supplement. There's the DEAR, the Department of Energy Acquisition Regulation, and so on. Most agencies have some form of FAR supplement. Some of them are extremely detailed, like the DFARS, the Defense FAR supplement, and some of them are quite sparse. In addition, many agencies have internal agency guidance that also supplements the FAR. Those are not regulations and don't give contractors any enforceable rights. The FAR is maintained by something called the FAR Councils, which is run jointly by the Administrator of the General Services Administration, the Secretary of Defense, and the Administrator of NASA, the National Aeronautics and Space Administration. And the policies reflected in the FAR, of course, come from statutes enacted by Congress, from executive orders issued by the President, and also just based on tinkering through years of experience with what works and what doesn't work in government contracts. The FAR has 52 parts within it, and I'm just going to highlight some of them as we go through. Part 2 contains definitions. Now, the truth is that many of the parts contain definitions that apply to that part, but Part 2 contains definitions that apply broadly, and it's always important to look there to see if the words you're reading have a specific meaning. For example, what is a contract? Well, that's defined in Part 2. Part 3 is called Improper Business Practices and Personal Conflicts of Interest, and that deals with such things as what types of communications may contractors have with government officials during a procurement? What do government officials have to do if they're looking for jobs outside the government at the same time they're working on a procurement? There are provisions there about contractor ethics and other similar subjects. In Part 6, there are the requirements regarding competition and the exceptions to the competition requirement. There's a term full and open competition, which means anybody can bid, and then there's less than full and open competition, which could be anything from a limited competition, maybe limited to small businesses, or limited to companies that have been pre-qualified, as well as sole source contracts, which are contracts awarded to a specific company without competition. In Part 6, you'll find the 7 bases for awarding sole source contracts, such as compelling urgency or only one responsible source. The term responsible is a term of art defined in Part 9 under Contractor Qualifications, and no contracting officer may award a contract without finding that the contractor is, quote unquote, responsible. Part 8 is called Required Sources of Supplies and Services, and it discusses situations in which the government is required to buy from specific sources. For example, certain types of contracts should be set aside under the Javits-O'Day-Wagner Act for industries that employ blind people. There's an institution or a company called the Federal Prison Industries, which employs people who are in jail, and there are rules about buying from them. Those things are in Part 8. And most importantly, Part 8 is where you will find rules relating to the General Services Administration Federal Supply Schedule, which is a major way that the government buys commodities, pens, pencils, computers, furniture, and commercial services such as IT services. All of that is in Part 8. Part 9, as I mentioned, is Contractor Qualifications. That talks about the definition of being a responsible contractor. It also talks about organizational conflicts of interest, which are rules that say that contractors shouldn't get contracts that will put them in an inherent conflict. For example, sometimes the government uses contractors to evaluate other contractors. You can't have a contractor evaluating itself. That would be an organizational conflict of interest. And that's just one example. That is discussed in Part 9. Part 12 deals with acquisition of commercial items, how the government buys things that don't require complicated solicitations, but rather can be bought in a more simple fashion because they are commercial items. Part 15, contracting by negotiation, sets forth the rules for receiving and evaluating proposals from contractors. How to evaluate a technical proposal, how to evaluate past performance, how to evaluate cost, what types of tools the government evaluators have, how requests for proposals should be structured, what type of information to ask for. That is in Part 15. Part 16 discusses types of contracts. There are fixed price contracts, there are cost reimbursement contracts, there are time and materials contracts. When do you use one versus the other? If there's more risk for the contractor, then it's fair to give the contractor a cost reimbursement contract. If it's something that contains relatively little risk, then a fixed price contract is likely to be more appropriate. That is discussed in Part 16. By the way, I'm skipping numbers, but that's not because the other sections don't exist. I'm just trying to highlight some of the main aspects of the FAR that contractors deal with or that get litigated. Part 19 deals with small business programs, how the government sets aside contracts for small businesses, for small disadvantaged businesses, minority-owned businesses, women-owned businesses, service-disabled, veteran-owned small businesses, who qualifies to be such an organization. Now that is, the main rules about that are actually found in the regulations of the Small Business Administration in Title 13 of the Code of Federal Regulations, but some of that is found as well in Part 19 of the FAR. Part 22, application of labor laws to government acquisitions. That's where you'll find the rules relating to the Service Contract Act, the Davis-Bacon Act, the various executive orders that I mentioned, both Executive Order 11246 as well as the more recent executive orders issued by President Obama, some of which have not gone into effect yet at the time that this recording is being made, but when there are rules, that's where they will be in Part 22. They are in various stages of being developed by the government at this time. Their other sections include Part 23, which discusses environmental and renewable energy, occupational safety and health, drug-free workplace. Part 25, foreign acquisition, that's where you'll find the rules relating to the Buy American Act and the Trade Agreements Act. Part 27 deals with patents, data, and copyrights. If you are developing software, for example, under your contract, and you're going to need to know what rights the government is taking from you, what rights you keep. Same thing if you invent something and there may be patent rights at issue. All of that is in Part 27 of the FAR. Part 31 is contract cost principles and procedures. This describes things that the government will not pay for. Whether you have a cost reimbursement contract, whether as a direct cost under a cost reimbursement contract or an indirect cost as part of your overhead rates, you're not allowed to charge the government for alcohol, for example. You're not allowed to charge the government for certain activities relating to attempts by your employees to organize as a union versus other costs that are allowable. All of that is in FAR Part 31. You're not allowed to charge the government for suing the government, generally. There are exceptions. And similarly, if the government sues you and you are found to have committed a fraud against the government, you can't charge the government for defending yourself. So those things are in Part 31. Part 33 discusses protests, disputes, and appeals. How do you protest if your competitor wins the contract and you think you should have won it? And we'll talk more about protests later. How do you file a dispute if the government doesn't pay you adequately when it cancels that garage and makes you build that swimming pool that I talked about before. All of that is in Part 33. Part 42 is called Contract Administration and Audit Services, and it discusses some of the oversight that the government has over contractors. It talks about evaluating past performance. The government is supposed to evaluate a contractor's past performance in writing with at least once a year, if not twice a year, and at the end of the contract. And there's a whole system for that. Contractors have rights as well. Part 42 also discusses how the government will audit you, audit your contract. If your company is sold while it has a contract, there are things you have to do to transfer the contract to the new owner of the company, and that's discussed in Part 42. Incidentally, you cannot sell a government contract by itself. That's prohibited by another law that I didn't mention called the Anti-Assignment Act. Part 44 has subcontracting policies and procedures. Part 45 talks about government property. That is, if the government is giving you property to use in the contract, you might be performing the contract on a government site with government furniture or government computers, and that's covered by Part 45. Part 48, value engineering. Sometimes you can suggest a better way to do something, and the government will pay you part of the savings. That's in Part 48. Part 49 talks about terminations, which I mentioned before. Part 52 contains solicitation provisions and contract clauses. All of the things that I mentioned have to get into your contract somehow, and the contracts don't just incorporate the entire Federal Acquisition Regulation. Rather, there are contract clauses that implement these various provisions into the contracts as appropriate to a specific type of contract. And those are the clauses in Part 52 of the FAR. So that's a summary of what's in the FAR. Now I'm going to go back and more slowly highlight some of the aspects that I mentioned. So the first topic I want to talk about is what's called procurement integrity. And FAR section 3.104-3B, as in boy, says that a person must not knowingly obtain contractor bid or proposal information or source selection information before the award of a federal agency procurement contract to which the information relates. That means that you are not permitted to improperly obtain your competitor's information or information about how the government plans to evaluate proposals. And the penalties for this can include not only not getting the contract or having your contract canceled if it was already awarded, but also prison and criminal and civil fines. There was a very well-publicized case, must be close to 10 years ago now, in which a very high-ranking Air Force official went to jail for accepting a job with a major defense contractor and helping that contractor win a contract. So it's a very serious matter, and there are very serious penalties. In addition, a government official who gives out contractor bidder proposal information may be violating other laws, such as the Trade Secrets Act, which is a separate criminal law. The procurement integrity provisions also impose limits by contractors on payments to influence federal transactions. There are whistleblower provisions for contractor employees. There are restrictions on hiring recently retired government officials. There are an entire slew of laws that prohibit government officials from taking different kinds of jobs within different time periods after leaving the government. Some types of jobs are prohibited forever, some for 2 years, some for 1 year. And if you're thinking of hiring a government official, a former government official, you want that person to obtain an ethics opinion from his or her agency lawyers setting out what that person is allowed to do in post-government life and not allowed to do in post-government life. And that will help you, the contractor, stay out of trouble, or you as your client, if you're an attorney representing a contractor, help the contractor stay out of trouble. Also, the procurement integrity provisions include prohibitions and restrictions on paying contingent fees. You're not allowed to, under certain circumstances, pay finder's fees to people who help you get government contracts, because there's a concern there that there could be bribery. And so it's not absolutely prohibited. There are rules about when it's permitted and when it's not, and that's in the sections that discuss the covenant against contingency fees. Part 3 of the FAR also contains the rules for the Contractor Code of Business Ethics. This is a pretty new requirement, maybe 5 years old, which requires contractors to have a written code of business ethics and conduct, to make a copy available to each employee who's performing the contract, to exercise due diligence to prevent and detect criminal conduct, to promote an organizational culture that encourages ethical conduct and a commitment to compliance with the law, to timely disclose evidence of certain crimes, even though the Constitution contains a protection against self-incrimination, but in exchange for getting a government contract, you agree that in some cases you will incriminate yourself. You'll report yourself to the government. Establish an ongoing business ethics awareness and compliance program, and conduct effective training programs relating to compliance. And there's an important point there that, and it's doesn't just relate to government contracts, but to any area where compliance is required, for example, in the area of labor law. It's not enough to have policies and handbooks and manuals. You have to have effective training programs to tell the relevant employees and managers what those handbooks and policies say and how they should implement them. So that is part of the Contractor Code of Business Ethics. Some of that is watered down for small businesses. The requirements are a little bit lighter in recognition of the fact that small businesses have fewer resources and fewer contracts and fewer employees. Part 6 of the FAR, as I mentioned, discusses competition requirements. Now, one of the things that the FAR requires in order to make sure the government gets adequate competition is that all procurements be publicly advertised. And there's something called the government-wide point of entry, which is a fancy way of saying that there's supposed to be one source for all government procurements. In fact, there isn't. Not all government agencies use this one source, which is the Federal Business Opportunities website, or www.fedbiz.gov. Their Department of Energy has another site, and some other agencies have their own sites. But in theory, everything is supposed to be on the fedbizops.gov site. That includes solicitations, amendments to solicitations, notices about upcoming procurements, requests for information to help the government determine whether there will be competition or whether a sole source contract might be appropriate. And prospective contractors are on notice of anything that's posted on the fedbizops.gov site. You can't protest and say, I would have bid on this, but I didn't know it was out on the street. You should have looked on the website. And you can set it up to give you notices. You put in keywords about things that you or your clients want to bid on, and then the appropriate person will get notices whenever something potentially relevant shows up on the site. In addition, if the notice is posted there that a contract has been awarded, then other contractors are on notice that the contract has been awarded, and it may trigger timeliness deadlines for protests and other purposes. It may not. Those are complicated rules in themselves, the timeliness rules for protests, but potentially it could. As I mentioned, there are different types of competition. There's full and open competition, which means everybody can bid. There's full and open competition after exclusion of sources, which means there will be competition, but not everyone can bid. For example, something may be set aside for small business concerns, so there will be full and open competition among small business concerns, but large companies need not apply. And then there's other than full and open competition, and there are 7 circumstances that permit other than full and open competition. The most commonly used are compelling urgency and only one responsible source. And when the government uses one of those, it's required to complete a justification. Sometimes it's called a justification, sometimes it's called a DNF, determination and findings, but some written document that explains why other than full and open competition is being used. And the contractor, the would-be contractor who didn't get that sole source contract can protest, and that written document will become evidence. And so, for example, we had a case years ago where the Air Force was buying aircraft engines, and it gave Rolls-Royce a 5-year sole source contract saying only Rolls-Royce could meet the schedule. Our client protested, and the what was then called the General Accounting Office, now called the Government Accountability Office, which rules on bid protests, said, come on, Air Force, if you have an urgent need for aircraft engines now, I could understand that, but how does that justify a 5-year contract? So make your sole source contract for 1 year and then hold competitions for the years beyond that. Hold competitions now for the years beyond that, and in the meantime, get your engines on a sole source basis from Rolls-Royce. And that ruling was based on the lack of a proper justification for a 5-year contract. Now, the requirement for competition requires as well that there be a published and equally applied basis for evaluating proposals and making award. If my proposal and your proposal are evaluated on different bases, then there hasn't been proper competition. So the government, when it issues a solicitation, is supposed to say what the basis for award will be. It might be best value, which means weighing price versus technical. The better proposal that costs more might be a better value than the not so good proposal that costs less. Or the government might decide, in this case, we want the not as good proposal that costs less rather than the super duper proposal that costs more. And that's called a best value determination. Another basis for award is called the low price technically acceptable, where the government says, we're not going to give proposals, excellent, outstanding, very good, satisfactory. We're just going to say acceptable or not acceptable. Either you meet the minimum requirements or you don't. Then we're going to take everyone who met the minimum requirements, everyone who was acceptable, and we're simply going to make the award to the low price proposal. That's called low price technically acceptable. It's been used a lot more in recent years than before, and a lot of people don't like it, and a lot of people are trying to tell the government, you get what you pay for, so if you buy the cheapest thing that meets the minimum requirements, you're going to end up buying it a second time when it breaks down. So it's not necessarily the best way to go. But in a time of shrinking budgets, sometimes the government feels pressured to just buy the cheapest thing that's out there. So that's what the tension is between the different ways of making award decisions. Solicitations also have to state the evaluation criteria. How will proposals be evaluated, whether it's on a best value basis or a technically acceptable basis. What is it we're evaluating? And typical evaluation criteria can include the technical approach, how do we plan to do what we do, and in a well-written proposal, it will also explain why do we intend to do what we do, rather than just spit back the requirements. We will build this building by April 1st. Well, how are you going to build the building by April 1st, and why is that the best way to build the building? Now, building buildings typically is not acquired through this kind of proposal, so instead of building, maybe, say, computer network. How are you going to build the computer network and why are you going to do it that way? That's the technical approach. The management and personnel sections, if they are required, will describe who will do it, why is my proposed project manager the best project manager in the history of this agency, why do you want him versus someone else? My guy has 40 years of experience, or he has a PhD, or she invented this or that. Whatever it is, you'll explain why that person is the best one for a job, why your key personnel are the best, how you plan to hire people, how you plan to retain people, what kind of benefits you offer that your competitors don't offer, and so on. That would be in the management or personnel section. Another typical section you find is the experience section. Have you done this work before? You want a contract to design an airport? Tell me about the airports you've designed before. And there's a past performance section in which discusses how well have you done this work before. The experience and past performance are different. People sometimes confuse them. Experience is what have you done before. Past performance is how well have you done it before. And usually the past performance is not based on your say-so, but rather you will take questionnaires that the government included in the solicitation, and you'll send them out to whichever customers you think will give you the best references, who will also be relevant. You want references that for whom you have done work that is relevant, similar in size and scope to the contract you're trying to get, and hopefully recent. If you've done this type of work 20 years ago, it's not that relevant to what you're going to do now, because you probably have different employees, different managers, and different tools. So that's the past performance section, the questionnaires. Of course, you will also write part of the past performance section where you will toot your own horn about how well you've done things, and you may need to use that opportunity to explain away bad performance that you've had. Sometimes you can't hide that. It might have been a bad contract for exactly the same agency, so they know about it. You can't hide it from them, so you want to explain it. Why was that not typical of the work that you're going to do? And the last typical evaluation factor is price or cost. And the difference between price and cost is price is, I will do this for $1 million. And the government will pay you $1 million. And if you did it for $800,000, you'll make a profit. If you did it for $2 million, you'll lose money. That's your tough luck, because it was a fixed price contract. Cost means you tell the government, I estimate this will cost $1 million. But if it's a cost type contract, a cost reimbursement contract, then if it costs you $800,000, then the government's going to pay you $800,000. If it costs you $2 million, the government's going to pay you $2 million, because your $1 million was just a cost estimate. There are also contracts called cost plus incentive fee contracts, in which if you come in under your estimate, you get a bonus. If you come in above your estimate, you might get penalized. So, let's say your estimate was $1 million and it cost you $1.5 million. Maybe the government will only pay you $1.3 million. Whatever the deal is in the contract, but the point is that such contracts exist. They're not pure cost reimbursement contracts. So the government's supposed to tell you in the solicitation what the basis for award will be, and how proposals will be evaluated, what information you're supposed to include. All of that is intended to enhance competition by having competitors compete on a level playing field. The FAR, Part 15, also talks about how proposals are evaluated. The evaluation factors are supposed to have, and any significant sub-factors are supposed to be assigned weights, which is more important, which is less important, and that is supposed to be done before the procurement, before the solicitation was issued. And again, everybody has to be treated equally. You can't consider price more important for me and technical more important for someone else. The government is always required to consider price or cost and should always consider past performance. The other evaluation factors should be used when they are appropriate. The quality of the product or service must be addressed in every source selection somehow, whether through past performance or evaluating technical excellence management capability. There should be some factors. It shouldn't be price only, except in rare cases when what's called sealed bidding is appropriate, which is price only. For example, straight construction projects that don't involve design, just building something, building a building, might be done on a sealed bid basis where only price is considered. When the government gets proposals under FAR Part 15, it might make award based on initial proposals, or it might decide that none of the proposals is quite ready for prime time, and it's appropriate to hold discussions with the offerors. Discussions means an exchange with offerors after establishing the competitive range. If the government got 15 proposals, it might say, well, we're going to talk to the top 3 or top 4, and that's called the competitive range. And then the government will hold discussions with those 3 or 4, or it might be 5, it might be 10, whatever number the government thinks is appropriate. If you are not included in that competitive range, you have the right to file a bid protest against the fact that you were not included in competitive range. The discussions may include negotiations in which the parties bargain about the contents of the proposal, or the government, and this is more typical, the government will just say, your price seems to be too high, or your price seems to be too low. Maybe you don't understand the work. I once bid for a government contract myself, and the government called us in and said, we really like your technical approach. We think you're the best, in fact, but your price seems unrealistically low. Maybe you don't understand what we're asking. And we said, sure, we understand what you're asking, and we'll raise our price. And we raised our price, we got the contract, and made a big profit because we understood the work very well and knew that it could be done at the lower price. The government, for some reason, didn't think it could. Usually, it will be the other way around. The government will think your price is too high, and you'll end up lowering it. But sometimes it works in the opposite direction. The government can have discussions with offerors in the competitive range about any aspect of the proposal: price, schedule, technical requirements, contract type, and other contract terms. The discussions are supposed to be tailored to the needs of the specific offeror. So you might, if you're the government, you might have questions about my price and not have questions about my competitor's price, so you're not going to talk to my competitor about price. But you do have to have some type of discussions with each offeror in a competitive range, even if it's just to say, great proposal, I have no questions. That will rarely happen, though. The primary objective of discussions is to maximize the government's ability to obtain the best value. There's some things the government may not do in discussions. It should not engage in conduct that favors one offeror over another. It should not reveal one offeror's technical solution to another offeror. It shouldn't say, hey, your competitor is doing it this way. What do you think about that? Could you do it that way also? And could you do it better? Your competitor thinks it can do this. Could you do that better? Not allowed to do that. You're not allowed to, the government that is not allowed to reveal the names of individuals who provided past performance information, and the government's not allowed to give out its internal source selection information. The government also is not allowed to reveal other offerors' prices, although it could tell you your price is too high or too low. Not that it's too high or too low compared to competitor X, but just that it's too high or too low. If you didn't win the contract, you might file a bid protest. And there are 3 places that bid protests can be filed. They can be filed to the agency, they can be itself, they can be filed to the GAO, the Government Accountability Office, or the U.S. Court of Federal Claims. There are different types of protests that are filed at different stages, and there are strict timeliness requirements. If you have a complaint about the contents of the solicitation, you have to protest before the due date for submitting your proposal. If you were excluded from the competitive range, you generally have to protest within 10 days of finding that out. If you didn't get the award, then depending on what type of solicitation it was, you may have to protest within 10 days of not getting the award, or you may be entitled to something called a debriefing, in which the government tells you why you did not get the award, and then you would have to protest within 10 days of the debriefing. And that all depends on whether the solicitation was under FAR Part 15 versus FAR Part 12 or FAR Part 14. Different methods of procurement that the government uses lead to different protest timelines and different protest rights. But the timeliness requirements are very strict, at least at GAO, and they will generally, almost never, I should say, consider an untimely protest, only if it raises a very novel issue that's significant to the entire government contracting business, and most things have been resolved, so that almost never happens. When you do file a protest, it won't necessarily lead to a decision by GAO. Only about 15% of all protests lead to a decision in favor of the contractor, but approximately 40 to 45% of protests lead to some kind of outcome that is favorable to the protester, and that's because the agency can take corrective action, meaning the agency can say, oops, we made a mistake, we're going to do this over again. That doesn't mean that the protester will get the contract, but it does mean the protester might get a second chance. So if you have a complaint against the solicitation because you think it's ambiguous or it's overly restrictive, or the response time is too short, or it contains the wrong clauses, for example, it contains the Service Contract Act instead of the Davis-Bacon Act, or it's improperly set aside for small business or improperly not set aside for small business. Those are all things that need to be protested before the due date for submission of proposals. And if you don't, you're out of luck. You can't say, well, I'll wait to see if I win the contract, and if I don't, then I'll protest that the solicitation was ambiguous. It's too late. You can't do that. Post-award, you would typically be protesting that your proposal and the winner's proposal were not evaluated properly. You'll say that the evaluation criteria were not followed, or the best value trade-off analysis, that is weighing the cost versus the technical, was not done properly, that you were improperly assigned weaknesses or not assigned strengths, or that your competitor was improperly assigned strengths and not weaknesses, or that the cost realism analysis determining whether your cost reflects an understanding of the work was not done properly. Now, sometimes, often, protesters want to also throw in a bias. This agency hates me, or this evaluator is biased against me. He should not, or the source selection official is biased against me. Such protest grounds very, very rarely succeed, and many attorneys, including myself, discourage them from being filed at all, because all they do is they reflect badly, unless they're really solid, such as your ex-spouse was the source selection official. and told you, outside that you will never get a contract as long as he or she lives, and you have a recording of it, it has to be really egregious for a bias protest to succeed, and it just reflects poorly on the credibility. It makes you look like a sore loser, and we generally discourage them. I mean, there have been cases where they could be appropriate. If the agency used a contractor to evaluate proposals, and that contractor was also bidding on the procurement, then there's obviously a bias, but there are other procedural hoops to go through in order to bring such a protest. So examples of winning protests might be that the agency did not follow the evaluation criteria, the agency relied on factors that were not part of the evaluation criteria, the agency's evaluation of the offeror's experience unfairly distinguished between offerors. We both proposed building a table just like this, and in my case you said it was not relevant, and in his case you said it was relevant, and those kinds of distinctions, or the source selection decision considered an undisclosed evaluation criterion. Those are the kinds of protests that are usually successful. Not usually, I shouldn't say usually. If a protest is successful, they usually have those kinds of grounds in them. As I said, most protests are not successful at all. Another type of winning protest might be that the agency did not reasonably support a claim that it needed to make a sole source award because they wrongly or without justification said only one firm is capable of meeting the agency's needs. Common reasons that protests are denied is that the agency's evaluation was reasonable and the protester merely disagrees. The important thing to remember is that the protest deciding officials, whether it's the GAO or the U.S. Court of Federal Claims, are not going to reevaluate proposals and say, we think this one should win. All they're going to do is look at the agency's exercise of its discretion and say it was reasonable or it was not reasonable. The fact that GAO might have come to a different conclusion if it was evaluating proposals is irrelevant. The agency's discretion in how it evaluates proposals and selects one of them for award is extremely, extremely great. And that's why the overwhelming majority of protests do not succeed. And a protest that merely disagrees with the agency is doomed to lose, and it's just a waste of money. Sometimes incumbents don't win the follow-on contract and they protest, only to discover that the reason they didn't win it is because they suffered from incumbentitis, which is taking for granted that they were a shoo-in to win again. The agency likes me so much that of course I'm going to win again. Well, the news here is that a proposal for government contracts is like a college essay. The graders, the evaluators, have a checklist of things they're looking for. And if you were supposed to write 5 pages and you didn't write 5 pages, the professor takes off points. If you were supposed to address points A, B, C, D through Z, and you only addressed half of them, the professor takes off points. And the same thing is true of a proposal, and it doesn't matter how good you are or how well they know you or how much they like you, you're not going to win, at least you shouldn't win, if you wrote a lousy proposal. And if you do win with a lousy proposal, you may be protested and you may be thrown out as a result of the protest. As I mentioned, there's a part of the FAR called Contractor Qualifications. That's Part 9, and it talks about being a responsible contractor. In addition to deciding that your proposal is the best, the contracting officer has to determine that you have the financial resources to perform, to meet the schedule, that you have a good record of business ethics, and certain other things that are listed in Part 9. One of President Obama's executive orders Executive Order 13673, known as the Fair Pay and Safe Workplaces Executive Order, would also require contracting officers to take into account your record of compliance with more than a dozen labor laws, and it would require contractors to disclose past violations of laws. And it remains to be seen whether that will ever take effect. Congress, in the budget for fiscal year 2016, took some steps to make it harder for those rules to go into effect. When the president issues an executive order, it doesn't go into effect the next day. Regulations have to be issued to implement it, and we're still waiting for final regulations on the Fair Pay and Safe Workplaces Executive Order. Many contractors are hoping it never goes into effect, and it remains to be seen. As I mentioned, there are also rules about organizational conflicts of interest, and FAR Part 9 also talks about debarment, where contractors are punished for wrongdoings by being told they're not eligible for contracts anymore or for a certain amount of time. And that can be open-ended, or it can be a fixed period of 3 years, depending on what the violation is. And sometimes there are things contractors can do to get back in the good graces of the government, and sometimes there aren't. I mentioned that there are labor policies affecting government contractors. In addition to the ones that I mentioned already, there are rules about equal opportunity for veterans, equal opportunity for workers with disabilities, and all of those labor requirements are found in FAR Part 22. If the contractor has a cost reimbursement contract, so there are rules about what kind of costs will be paid. In order to be paid, a cost has to be allowable, reasonable, and allocable to the contract. Whether it's allowable is determined by whether it falls into one of the many exclusions from allowable costs. As I mentioned, the cost of alcohol, the cost of suing the government. Those are unallowable costs. If you pay the executives of your company more than a certain amount, that could be an unallowable cost. In addition, costs have to be reasonable for that particular situation, and the costs have to be allocable to the contract. So if I bought paper, did I buy paper for this contract? Or did I buy paper for some other contract? Or did I buy paper for the office, in which case it should be allocated to all the different contracts? That's what allocability means. There are rules about how you account for unallowable costs, and rules for what should be direct costs, meaning costs that are charged directly to a contract, versus indirect costs, which are costs that are divided over many different contracts. Like the salary of the president of the company typically will be an indirect cost. In addition to the cost principles that I mentioned about legal costs and alcohol, entertainment costs, there are rules about what's reasonable compensation for employees. There are rules about what is reasonable for professional consultants, for paying your accountant. There are rules about independent research and development costs, and many others, several dozen cost principles altogether. I mentioned that a contracting officer may make changes at any time within the general scope of the contract, and changes may be ordered changes or constructive changes. An ordered change is when the contracting officer tells you, don't build a garage, build a swimming pool. A constructive change may be where the contracting officer gave you some order that indirectly resulted in a change to the contract. So in both cases, you may have additional costs, and you may submit what's called a request for equitable adjustment. Request for equitable adjustment means a request to the government to adjust the cost of your contract, including giving you reasonable profit and overhead on that change. There's something called change order accounting, which is how you would generally prove what the cost of the change was. So if they tell you to build a swimming pool, you need to open a separate charge account for the cost relating to that swimming pool, so you'll be able to prove what it cost. If you didn't do that, it might still be possible to recover the costs, but it's more difficult. If the government doesn't pay you what they're supposed to pay you, you could submit a claim. And there are specific requirements for a claim. If it's more than $100,000, it has to be certified, and there's a certification language in the disputes clause of the contract. Once a claim is certified, the government will start owing you interest on the claim, assuming you win in the end. And the way that a claim goes is you submit it to the government. The contracting officer is supposed to issue what's called a contracting officer's final decision. And if that final decision is not what you wanted, then you have the right to appeal to the appropriate Board of Contract Appeals or to the U.S. Court of Federal Claims. As I mentioned earlier, the government has the right to terminate a contract for convenience. When you get a termination order, you are supposed to stop work immediately and do whatever you can to mitigate the damages. So tell your workers not to come in tomorrow. So you may still have to pay them, but you'll save on the electricity that they would have used. If you had orders of materials coming from somewhere, call up the supplier, try to stop the orders from being delivered, things that will mitigate the damages. But inevitably, there will be costs that cannot be avoided, plus the cost of the work you already performed, and the contractor has rights to be paid for those costs. If the contractor is terminated for default, the government has the right to get a new contractor to finish the job and charge the difference in price to the contractor that was terminated. The contractor that was terminated for default has the right to appeal and say, I wasn't in default, change it to a termination for convenience so that I, the contractor, can get money from the government. You cannot force the government not to terminate the contract. You can just change the nature of the termination from default to convenience. Lastly, another law that regulates government contracts is the False Claims Act. Under the False Claims Act, it is a crime to knowingly present or cause to be presented a false or fraudulent claim for payment or approval, or to knowingly make, use, or cause to be used a false record or statement material to a false claim or false or fraudulent claim. For this purpose, every invoice that a contractor submits is a claim. And the false claims can be pretty broad. I remember a case where a contractor provided a foreign-made item and certified that it was U.S. made and was accused of a false claim, even though the foreign-made item was better than the U.S.-made item. And that case was settled. Obviously, the government's not terribly damaged if it gets a better product, but the point is that it could result in accusations of a false claim. There's something called a qui tam action, in which a whistleblower files the lawsuit on behalf of the government and can win a substantial amount of money as a kind of a finder's fee for bringing this to the government's attention. So it's something that you want to stay away from. Government contracting is quite complex. As one of my professors in law school said, many new contractors will either make a bundle or lose their shirts and go bankrupt. I've seen contractors who have gotten in over their heads go bankrupt, unfortunately. And of course, many of the very well-known government contractors make billions of dollars in profits. It's very important for contractors to have good legal advice about government contractors. I frequently tell people, you wouldn't go to a podiatrist for open heart surgery, and you wouldn't go to a cardiologist for an ingrown toenail. And in the same way, don't come to me for tax advice, but don't go to your tax lawyer for government contracts advice. And so it's important to be aware that there are very specific rules and that there are people who specialize in them. Thank you very much for your attention. I hope you found the program beneficial. Good day.